I will be
Peeler.
playing non-guilty today, and I will be representing myself.
Okay, there's a certain way we go through things. Just bear with me a second. So the first thing is that you're charged with failure to stop and give information. You're facing up to 6 months in jail and or 2,000. I know that you're ready to say, go through your list of this and that, but because you want to talk, you're not listening. I need you to listen for a second. I'll give you time to talk, I promise. Just let me get through the spiel and then I'll give you an opportunity, okay?
6 months behind bars for not giving your info after a crash sounds harsh, right? But here's the kicker: in most states, leaving the scene, even briefly, isn't just a traffic violation, it's a criminal offense. Do you think the punishment matches the crime here?
You're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, we're just going to do probable cause because I don't know what happened. Maybe there's no probable cause and then you're out of here. I don't know. Stop. You have the right to remain silent. Exercise that. They're DAs. Every single thing you say, they're going to sit there and type to use you.
I know that's my right.
Guilt. Just hold on. Let's do probable cause first. Okay.
Yes, Judge. On June 15th, 2024, officers were dispatched to a crash. They met with the complainant who reported that she was involved in a crash with a Toyota Tundra and provided the license plate number. The officer, the male with gray shorts, no shirt, and tattoos, stepped out of his vehicle and offered the complainant to follow him back to his house, and the complainant declined the offer. The defendant then left the scene without giving any information and sideswiped the complainant's vehicle a second time. The officers began to head to the car's registered address, 0.4 miles away, when they received a second call for help at the address they were headed to. At the address, a male matching the description provided by the complainant was having a mental episode in front of his house. The defendant admitted to driving and leaving the scene without giving information. The damage was approximately $2,000.
Okay. All right, Mr. Peeler, I'm going to find that there's probable cause to go forward with your case. How old are you, sir?
So on June 15th, I was in a state of psychosis, and I have
Hold on.
documentation of the settlement that took place for the liability property damage which occurred on that incident. I have the claim number in front of me if you need it, Your Honor, for that settlement.
Well, mental health crisis, settlement papers, disability claims. This defendant is pulling out every defense card possible. But here's the tension: will the judge see this as a genuine breakdown, or just an excuse? What would you decide if you were on the bench?
I have the mental health crisis documentation, discharge summary provided by the Harris County Constable living at 13800 Lake Superior Lane. If you need that, upon further request, I can provide documentation of the discharge from the hospital that I went to.
Let's do this.
Supporting the mental health.
Mr. Peeler.
And I'm disabled too.
Let's do this. Why don't I have you talk to a lawyer? Okay. Your lawyer can talk with you, get to know you, find out what happened, and then they can approach the state to try to, see what's going on.
I'm disabled and I don't want to be, and I never was.
Just don't say anything.
Warrant at all. I never received anything in the mail, not once. So how can
Sometimes cases work like that. Sometimes a person is involved in some kind of situation where a warrant will not issue immediately to where they get taken into custody at that time. Those are called.
In the mail, so I assumed that I would have received something.
Never assume anything.
You're right.
Never assume anything. But let's do this. I can have you talk to a lawyer here momentarily. You can explain your situation to the lawyer. The lawyers can talk to the DA, and then we can work something. Okay.
So
Just hold on. Hold on.
I agree.
I don't want you to say anything because there are a bunch of DAs here, and everything you say, they're going to use it against you. I will give you the opportunity, but first, let me have you talk to a lawyer. I've got a bunch of them, and they're great. They truly will help you out. Okay, really. Yeah. So let's do this. I'm going to have you go to Victoria, sign and reset. I'm just going to have you take a seat in the jury box while I find your lawyer. Be patient, though. I've got 150 people here, Mr. Peeler. Okay, so just be patient. Okay.
Failure to, well, I actually did stop. I mean, for the record, we both have exchanged words outside our vehicle.
Okay, come on.
Proctor, Bessie.
Good morning, Ms. Stokes. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On October 31st, 2024.
Imagine being legally banned from Walmart. No groceries, no late night runs, not even Black Friday deals. But jokes aside, this condition is serious. Break it, and she risks jail time. Now let's see how her felony theft charges stack up against this misdemeanor.
The officer was dispatched to a Walmart in Harris County, Texas, in regard to a theft. Upon arrival, the officer met with the complainant, the loss prevention staff, and the defendant. The complainant advised that she observed the defendant concealing items on her person along with skip scanning items at the register. The complainant then observed the defendant proceed to walk out of the store, passing all points of sale. Total cost was $49.92.
Stokes, I'm going to find that there's probable cause to go forward with the case. I'm barring you now, and I'm ordering you not to go to any Walmart for any reason. You understand? If I find that you go to Walmart and I don't care what your reason is, I'm going to put you in jail. You will not get any more PR bonds. You're already on bond for a felony theft as it is now. It's very possible they revoke your bond and issue a felony warrant for your arrest. What happened with the felony theft that she's on now?
Your Honor, on the felony theft, it says that the officers were on patrol and ran the vehicle through NCIC and noticed the vehicle was reported stolen. The traffic stop was conducted. The driver of the vehicle was identified as the defendant. The complainant identified herself as the sales manager of the auto dealership and stated the defendant came into her office to purchase the vehicle for $11,000. The complainant stated the defendant presented 3 money orders for $1,000 each as down payment. The complainant stated they only allowed the defendant to leave with, they allowed the defendant to leave with the vehicle. The complainant stated several days later she found out the money orders were stolen. The complainant contacted the defendant and told her to return the vehicle immediately, which were ignored.
And I see that she has yet another one from March of this year as well. Same thing.
Let me see, Your Honor. In that incident, she used stolen identifications and rented a car for 1 day and was supposed to return it, but failed to return the vehicle.
I'm ordering you not to drive. I'm making it a condition of your bond that you're not to drive. Do you understand? Do you have a Texas driver license?
Yes, sir. Yes, sir.
All right, Your Honor.
You know what? Let's do this. I'm going to appoint your lawyer today, ma'am, and then we'll talk about all your bond conditions. I'm going to have you sign a receipt of Victoria, and then I'm going to have you take a seat in the jury box, ma'am. Do not go away until we have you talk to the lawyer. Okay? Please.
Right this way. All right, Judge, next is page 19. Warzop, Emily.
Is it Miss Warzebach?
Warzbach.
Ms. Warzbach, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On October 23rd, 2024, the officer was conducting surveillance at a department store in Harris County, Texas. The officer observed the defendant enter an Old Navy. The officer made contact with the complainant, the loss prevention manager, who stated the defendant entered the store, selected multiple pieces of clothing, and walked towards the front of the store. The defendant abandoned merchandise on the table, but kept a white sweater. The defendant passed all points of sale with the unpaid sweater, causing alarms to sound. The officer observed the defendant remove the security tag and throw the tag on the ground. The officer made contact with the defendant and recovered the sweater.
All right. Okay, Ms. Warzbach, I'm going to find that there's probable cause to go forward with the case. I'm sending you now for a drug test. I want to know what, if anything, is in your system. I'll appoint your lawyer today, but sending you for a drug test. If you fail to go take the drug test, if you fail to come back, I will issue a warrant for your arrest. You will not get any more PR bonds. Do you understand, ma'am? Okay, take your seat for me, please.